The marble pillars of the U.S. Supreme Court seemed to echo with the crowd's collective gasp. Associate Justice Samuel Alito, widely recognized for his firm conservative philosophy and sharp courtroom style, had just mocked Congresswoman Jasmine Crockett's legal argument in front of the nation. "Congresswoman," he said, his tone dripping with sarcasm, "perhaps they teach constitutional law differently in Texas, but that's not how the First Amendment has ever been read by this court." Laughter rippled through the chamber. Several law clerks exchanged uneasy glances, and even a few of Alito's fellow justices appeared surprised by his dismissive tone, standing tall at the podium. Congresswoman Jasmine Crockett, representing the plaintiffs in a major voting rights case, paused only for a moment. Though the remark was clearly meant to undermine her expertise, she remained calm and composed. "Justice Alito," she began, her voice firm but respectful, "if I may, I'd like to direct the court's attention to our supplemental brief. Appendix C, page 14, what followed would silence the courtroom." The documents she revealed didn't just counter the justice's criticism, they transformed the constitutional foundation of the entire case. Before we break down what these powerful documents revealed and how they completely changed the court's perspective, make sure to subscribe and turn on notifications for more in-depth coverage of major Supreme Court moments. The mainstream media often overlooks moments that show how justice truly unfolds at the highest level. The court had taken up Martinez v. State Elections Commission, a landmark case challenging new laws on voter registration drives. The question was whether nonprofit groups could be forced to register with the state, submit their internal operation plans, and have every volunteer undergo government-approved training before helping citizens register to vote. The outcome would have national consequences. 17 states had already enacted similar restrictions, claiming they protected against fraud and registration errors. Civil rights groups, however, argued that these laws made it nearly impossible for local organizations, especially those serving minority voters, to continue their vital work. Justice Alito, appointed in 2006 by President George W. Bush, had long been known for his strict textualist approach to the Constitution. He consistently emphasized historical interpretation, state sovereignty, and minimal federal interference in election laws. Before joining the Supreme Court, Alito served as a U.S. attorney and later on the Third Circuit Court of Appeals, earning a reputation for incisive, sometimes skeptical questioning during oral arguments. So, what's your take on voter registration rules essential for election integrity or unfair barriers to participation? Share your thoughts below. Congresswoman Jasmine Crockett brought a very different legal tradition to the case. Before serving Texas's 30th district in Congress, she had built an impressive career as a civil rights attorney specializing in voting rights cases. Her legal strategy blended textual analysis, historical insight, and real-world impact, especially on marginalized communities. The Supreme Court's decision to let her personally argue the case, despite her congressional role, drew national attention. Such permissions are rare and signal the case's enormous importance. Lower courts had split sharply on the issue. One circuit struck down the laws as unconstitutional restrictions on free speech and association, while another upheld nearly identical rules as reasonable regulations under state authority. The resulting circuit conflict forced the Supreme Court to step in, with most analysts predicting a conservative ruling upholding the state's power. Oral arguments began predictably conservative justices emphasizing security and state control, liberals highlighting the burden on civic organizations. But when Crockett began her argument, the tone of the courtroom shifted instantly. Instead of relying solely on First Amendment arguments, she traced the historical roots of voter registration drives as core political association rights, protected not just by the First Amendment but also by the 14th. She presented compelling evidence that these regulations would unfairly hurt minority-led organizations. These laws don't just set procedures, Crockett explained. They give state officials power to decide who gets to help citizens register and who doesn't, an authority that historically has been used to suppress minority voices. Her reasoning drew the attention of Justice Elena Kagan, who leaned forward and asked, "Congresswoman Crockett, are you suggesting these laws should face strict scrutiny because they touch both associational and voting rights?" Crockett replied calmly, "Yes, Justice Kagan. The historical record clearly shows that community-based voter registration drives have long been essential in breaking down barriers to political participation, especially for marginalized and minority communities. Yet the state's new regulations directly targeted these efforts, imposing burdens that did not apply to other forms of political organizing. It was at this point that Justice Samuel Alito leaned forward, signaling his intent to intervene. What followed would become the extraordinary exchange that transformed the entire Supreme Court hearing. "Congresswoman Crockett," Justice Alito began, his tone sharp with skepticism, "you're arguing that these regulations deserve heightened scrutiny because they supposedly target certain communities. But the laws are facially neutral. They apply equally to all organizations conducting voter registration drives. There's nothing in the text that singles out any group." Crockett nodded respectfully before responding. "Justice Alito, while the text appears neutral, its application is not. Our record contains extensive evidence that these requirements disproportionately burden small, community-based organizations serving minority neighborhoods." "The administrative costs alone," Alito interrupted, a move not uncommon during Supreme Court arguments. "Many laws have disparate effects without triggering heightened scrutiny," he said. "Election regulations inevitably affect organizations differently based on their size and resources. That doesn't make them constitutionally suspect." "With respect, Justice Alito," Crockett continued evenly, "our argument isn't based solely on disparate impact. It's about historical continuity. When viewed in the context of this state's long record of restricting registration drives in minority communities, these regulations follow a deeply troubling pattern of suppression." "Counselor," Alito interjected again, his tone growing more dismissive, "historical context doesn't transform a neutral regulation into a discriminatory one. This court has repeatedly held that current burdens must be evaluated on their own terms, not through the lens of decades-old practices that have long since been abandoned." The tension was now unmistakable. Several justices shifted in their seats, sensing that the exchange had grown unusually pointed. Crockett, however, maintained her composure. "Justice Alito," she replied calmly, "we're not relying on outdated history. Our evidence includes recent legislative records with sponsors explicitly discussing how these requirements would limit organizations working in specific communities. Those statements don't prove discriminatory intent," Alito countered. "Legislators routinely discuss how laws might impact different constituencies. That's part of the democratic process." Crockett took a brief pause, then redirected. "Justice Alito, our position aligns with this court's decision in Meyer v. Grant, which recognized that petition circulation constitutes core political speech deserving the highest First Amendment protection. Voter registration efforts, too, are acts of political association and advocacy." That was when Justice Alito delivered the remark that would define the moment and ignite national headlines. "Congresswoman," he said, his voice carrying a trace of condescension, "perhaps they teach constitutional law differently in Texas. But that's not how the First Amendment has ever been interpreted by this court. Meyer dealt with direct political advocacy, not administrative registration. States retain broad authority to regulate the latter under Article 1. Scattered laughter broke out in the chamber. A few clerks exchanged uneasy glances. Even some of Alito's fellow justices seemed surprised by the dismissive tone and the implicit questioning of Crockett's legal expertise. Standing tall at the podium, Congresswoman Jasmine Crockett paused, unflinching. Her expression remained steady despite the attempt to undermine her credentials. "With respect, Justice Alito," she said, her voice firm but composed, "I'd like to direct the court's attention to our supplemental brief Appendix C, page 14. A quiet rustling of papers swept through the courtroom as the justices located the document. Allo's expression remained skeptical as he turned the page. This appendix, Crockett explained, contains internal communications from the State Elections Commission, produced during discovery. The highlighted email is from the Commission's legal director to the bill's sponsors, 3 weeks before the legislation was introduced. As the justices read, the room seemed to shift. Justice Sonia Sotomayor looked up sharply. Justice Brett Kavanaugh furrowed his brow as he flipped to the next page. Chief Justice Roberts studied the document with measured focus. The email read, "The registration, training, and operational plan requirements will effectively prevent most community organizations from conducting registration drives. This will be particularly effective in reducing registrations in targeted urban and minority-heavy districts where such drives have historically generated thousands of new voters unlikely to support our preferred candidates." The courtroom fell silent. Even Justice Allo's expression had changed from dismissive to intensely focused as he continued reading. The next page contained the Commission's internal analysis, confirming that nearly 85% of the organizations unable to meet these new voter registration requirements primarily serve minority communities, Crockett explained. Turning to the next document, she continued, page 16 provides a district-by-district breakdown showing the steepest declines projected exactly where minority populations are highest. Justice Elena Kagan leaned forward. Congresswoman Crockett, was this evidence presented to the lower courts? Only partially, Your Honor, Crockett replied. The most revealing communications were uncovered after the appellate decision. Our ongoing discovery revealed that these internal analyses had been deliberately withheld during the original proceedings. We filed a motion to supplement the record, and it was granted because of the new evidence's importance. Justice Allo had regained his composure but now seemed more careful. Counselor, he began, even assuming your representations are accurate, these communications reflect the opinions of Commission staff, not necessarily the legislature that enacted the statute. Crockett was ready for this. Justice Allo, she said confidently, if you turn to page 18, you'll see text messages between the Commission's director and the bill's sponsor. The sponsor's reply reads, "This is exactly what we need." The beauty is that nothing in the text explicitly mentions these communities, so it should survive legal challenge while achieving the desired outcome. Justice Amy Coney Barrett, who had remained silent up to that point, joined the questioning. Congresswoman, this evidence certainly raises concerns about intent by certain officials. But how do you respond to the state's argument that, regardless of improper motives, these regulations still serve legitimate interests in election administration? That question opened the door for Crockett to strengthen her broader constitutional argument. Justice Barrett, she replied, this is exactly where the First Amendment becomes critical. When a law burdens core political rights like association and expression, it must be narrowly tailored to serve a compelling state interest. The state's stated goal, administrative efficiency, can easily be achieved through far less restrictive measures. She continued, her tone steady and persuasive. Moreover, these internal communications show that efficiency was never the real motive. The evidence demonstrates that officials intentionally designed these requirements to suppress voter registration in specific communities. That makes this not just a matter of bad policy, it's a constitutional violation, where administrative rules become tools for viewpoint discrimination, something the First Amendment explicitly forbids. Justice Allo, now fully engaged, posed a new question that signaled a remarkable change in tone. Counselor, he said, if we assume your evidence accurately reflects legislative motivation, how would you have this court craft a remedy that corrects the constitutional violation while still allowing states to regulate voter registration? This question focused on remedy, not resistance, marked a turning point. Allo was no longer dismissing Crockett's expertise. He was actively engaging with her constitutional framework. Crockett answered with precision. Justice Allo, the court could apply the Anderson-Burdick standard. Under that precedent, any regulation that severely burdens political participation must be narrowly tailored to serve compelling state interests. When administrative requirements selectively target specific communities without genuine necessity, such rules should be presumed invalid. She paused, then concluded firmly. This approach preserves state authority to regulate elections while preventing the misuse of that power to suppress political participation. It also provides clear guidance for lower courts in evaluating similar laws in the future. As her time expired, Crockett had done what few advocates ever manage. She shifted the entire tone of a Supreme Court session. Through meticulous command of the record and constitutional doctrine, she turned skepticism into serious consideration. Even Justice Alito, who had once dismissed her argument with condescension, now treated it with respect when Chief Justice Roberts thanked her. There was a quiet recognition among those in the courtroom. They had just witnessed something rare, a moment where truth, evidence, and advocacy changed minds in real time. When the state's attorney rose for rebuttal, the courtroom dynamic had completely changed. Justices who once seemed ready to defend the state's position now pressed hard on its credibility. "Counsel," Roberts began, "how do you respond to the emails showing the commission designed these requirements to reduce voter registration in minority communities?" The attorney hesitated. "Mr. Chief Justice, those communications reflect only the personal opinions of staff, not the official stance of the legislature or the commission." Justice Brett Kavanaugh immediately followed up. "But the text messages between the commission's director and the bill's sponsor explicitly acknowledge a discriminatory purpose and even celebrate how neutral language conceals it. How can we ignore that?" "Justice Kavanaugh," the attorney stammered, "isolated communications don't represent the collective intent of the legislature." Then came the question that sealed the moment from Justice Alito himself. "Counsel," he asked, "even if we set aside legislative intent, doesn't this evidence at least create a strong inference that viewpoint discrimination played a role? And if so, wouldn't that trigger heightened First Amendment scrutiny under this court's own precedent?" It was a stunning reversal. The very justice who had mocked Congresswoman Crockett's First Amendment argument less than 30 minutes earlier was now echoing it. His words reflected not dismissal but respect for the legal framework she had so powerfully established. The state's attorney quickly understood the significance of this sudden shift. "Justice Alito," he began, "even if certain officials acted with improper motives, these regulations still serve legitimate state interests. Their purpose is to ensure accurate and secure voter registration. This court has long held that facially neutral election laws deserve deferential review." Justice Elena Kagan immediately seized on the point. "But that's exactly what Congresswoman Crockett argued," she countered. "When the record shows that neutral wording was deliberately used to hide discriminatory intent, doesn't that fundamentally alter the constitutional analysis?" Even Justice Clarence Thomas, who rarely speaks during oral arguments, joined in. "Counsel," he asked, "how do you reconcile the Commission's internal projections, showing these rules would reduce registration by over 80% in predominantly minority districts with your claim that the burdens are incidental?" As the questioning continued, the courtroom atmosphere changed entirely. The documents Crockett had presented reshaped the justices' understanding of the case. Even those who initially favored the state's position now focused sharply on the evidence of intentional discrimination and its constitutional impact. By the time arguments concluded, legal analysts were already predicting that the court might issue a sweeping ruling against discriminatory voting restrictions, something few had expected. From the current conservative majority outside the courthouse, reporters crowded around Congresswoman Crockett. The first question was inevitable. How did she stay calm when Justice Alito openly mocked her credentials? "My focus wasn't on personal remarks," she replied steadily. "It was on ensuring the court engaged with the facts. The documents speak for themselves. They turned an abstract debate over state power into a concrete case of intentional discrimination, precisely what our Constitution forbids." When asked about Justice Alito's apparent shift during the hearing, Crockett was poised and professional. Once the evidence was on the table, Justice Alito asked thoughtful, substantive questions, she said. That's how the judicial process is supposed to work. Arguments should be tested by evidence, not assumptions. Legal scholars quickly recognized the day's significance. Harvard law professor Noah Feldman told CNN, "What we saw today was extraordinary." A justice dismissed an advocate's legal theory, then adopted it once confronted with undeniable evidence. It proves that facts can reshape constitutional interpretation. At Georgetown University, Professor Paul Smith echoed that sentiment on social media. Congresswoman Crockett didn't rely on abstract doctrine. She directed the court to specific proof that changed the entire framing of the case. By that evening, the hearing was being hailed nationwide as a turning point. What had seemed likely to be a narrow affirmation of state authority now appeared poised to become a landmark voting rights decision. Legal blogs predicted that the court would rule that evidence of discriminatory intent triggers strict scrutiny. Even for facially neutral regulations, the exact argument Crockett had made, one prominent constitutional scholar summarized it perfectly. Justice Alito may have mocked Jasmine Crockett's legal training, but her mastery of the facts and the Constitution ultimately changed how the entire court saw the case. It's proof that evidence and precision still matter in the pursuit of justice. 3 months later, the Supreme Court issued its ruling in Martinez v. State Elections Commission. In a stunning 7-2 decision written by Chief Justice John Roberts, the court struck down the voter registration rules as violations of the First and 14th Amendments. Even more surprising, Justice Alito joined the majority rather than writing or signing a dissent. The majority opinion cited extensively from the very evidence Crockett had introduced, establishing a powerful new framework for evaluating voting. Restrictions with discriminatory intent. When plaintiffs present credible evidence that facially neutral voting regulations were designed to suppress identifiable groups, Roberts wrote, courts must apply strict scrutiny regardless of administrative justifications. States have broad authority to manage elections, but that power cannot be used as a pretext for discrimination or political suppression. The opinion directly referenced the emails and text messages Crockett had revealed. The record contains disturbing proof that officials deliberately structured these requirements to reduce voter registration in specific communities based on perceived political preferences. Such motives are incompatible with the state's duty to uphold neutral and inclusive election processes. The court also established a new burden-shifting standard when plaintiffs present substantial evidence of discriminatory intent. The burden shifts to the state to prove that the regulation would have been enacted regardless of that intent, and that it is narrowly tailored to serve a compelling state interest. This new precedent, far more protective of voting rights than observers expected, had immediate nationwide implications. Within weeks, 16 other states with similar voter registration laws suspended enforcement, announcing reviews or revisions to comply with the ruling. Legal experts across the country hailed the decision. Yale law professor Heather Gerken called it a defining moment for American democracy, adding, "This ruling provides a practical tool to challenge laws that appear neutral but are rooted in discriminatory intent. It establishes that motivation matters, a principle that will resonate across all areas of constitutional law." For civil rights organizations, the decision became a legal breakthrough. The NAACP Legal Defense Fund quickly announced plans to challenge several election laws under the new framework. Focusing on statutes where documentary evidence revealed discriminatory motives hidden behind neutral language, the victory was not just legal, it was symbolic. Congresswoman Jasmine Crockett had faced skepticism and ridicule at the nation's highest court. Yet her preparation, composure, and command of the record reshaped constitutional doctrine and reaffirmed the power of truth in the pursuit of justice. State legislators across the country quickly responded to the Supreme Court's landmark ruling. In states with pending election legislation, lawmakers revised their proposals to ensure compliance with the new constitutional framework. Legislative council offices issued detailed guidance warning that any internal communications revealing discriminatory intent could now invalidate otherwise lawful regulations. The message was clear: election measures must be justified by genuine administrative needs, not political or demographic targeting. The decision's ripple effects reached academia as well. Law schools swiftly integrated Martinez v. State Elections Commission into constitutional law courses. Using the oral exchange between Justice Alito and Congresswoman Jasmine Crockett as a case study in how compelling evidence can reshape judicial interpretation, new seminars on evidence development in voting rights litigation emerged, underscoring how factual discovery can determine constitutional outcomes for Congresswoman Crockett. The rulings served as powerful validation of her legal strategy and advocacy. In national interviews, she downplayed personal triumph and emphasized the broader democratic principle affirmed by the court. This decision reinforces that our democracy cannot be manipulated through laws designed to silence specific communities, she explained. When evidence shows discriminatory intent, courts must look beyond neutral language to uncover the true purpose and impact of voting restrictions. When asked about her now famous exchange with Justice Alito, Crockett remained composed and substantive. The focus was never on tone, it was on the evidence, she said. The record revealed the real motivation behind these laws, and the court correctly placed that evidence at the center of its analysis. In a later address to the American Law Institute, Justice Alito himself appeared to reflect on that transformation. Without naming the case directly, he spoke on the importance of judicial openness. Judges must remain willing to have initial impressions changed by evidence and argument. That flexibility is not weakness, it is the essence of sound judicial reasoning. Many observers viewed this as a quiet acknowledgement of how Crockett's factual presentation had shifted his own understanding during oral arguments. The Martinez ruling soon reshaped voting rights litigation nationwide. Lower courts adopted the new framework, giving unprecedented weight to proof of actual discriminatory intent rather than accepting facial neutrality at face value. Within a year, multiple restrictive voting measures were struck down, and a Brennan Center for Justice study estimated that litigation under the Martinez standard had restored voting access to nearly 1.8 million Americans. In classrooms, law professors replayed the oral argument to illustrate effective advocacy. "Watch how Crockett never takes the bait," one professor told her students. "She redirects every dismissive comment back to constitutional evidence." That's precision advocacy anchoring persuasion in substance, not emotion. The Martinez decision also transformed how legal teams prepare Supreme Court cases. Top litigators began emphasizing the discovery of documentary evidence over purely doctrinal argument, recognizing that facts, when properly developed, can transcend ideology. As one leading advocate wrote after Martinez, "Every serious constitutional challenge starts with evidence, not rhetoric." Ultimately, the case demonstrated that constitutional law evolves through the interplay of evidence, argument, and judicial reasoning. As Stanford's Professor Pamela Karlan observed, Martinez proves that when confronted with undeniable evidence of discriminatory intent, justices across the spectrum return to first principles, the Constitution's guarantee of equal participation in democracy, the legacy of that extraordinary oral argument, beginning with a dismissive remark and ending in a historic affirmation of voting rights, continues to influence both advocacy and judicial philosophy. As Georgetown Law Dean William Treanor reflected, Martinez reminds us that constitutional interpretation is not static. It grows through courage, clarity, and the power of truth. If this story of evidence-driven advocacy inspiring judicial transformation moved you, don't forget to like and subscribe. We bring you the most consequential Supreme Court moments that show how facts, not ideology, shape constitutional history. Share this with anyone who believes in the power of advocacy, evidence, and democratic integrity.